I'm Reed Bloodworth, the managing partner of Bloodworth Law, with offices in Winter Haven and Orlando, Florida. We handle trust and probate litigations across the state and travel to your counties, your courts, and your cities. From Tampa to Daytona, Pensacola to Miami, and most locations in between. Today, I'm going to talk about some of the most common acts of fraud in trust and probate disputes. Fraud, in regards to a will or a trust, is defined as deceiving, tricking, coercing, or lying to the grantor to cause them to establish a will or a trust that favors the person that was committing the bad acts. If you believe a will or a trust was obtained through fraudulent means and you want to pursue litigation, you'll need to move quickly. Florida has 20-day, 60-day, and 90-day deadlines for you to file disputes, depending upon if it's a trust or probate dispute. Here are the deadlines to be aware of. You have approximately 90 days after the notice of administration has been provided to you to contest a will. You have even less time to dispute a trust, which allots you as little as 60 days to file a dispute. You may only have 20 days to dispute a will in the event you're served with formal notice of the probate proceeding. Some examples of fraud relating to wills and trusts include fraud in the inducement and fraud in the execution. Fraud in the inducement occurs when someone convinces a testator or grantor through deception that something fraudulent is true and that the will, trust, or provision thereof results from that deception. In other words, before a will or trust was signed, fraud was used to induce someone into signing a will or trust. For example, a family member lies about a beneficiary being a criminal in an attempt to get more money left in a will or trust to themselves, when actually the beneficiary was not a criminal at all. This belief could cause a testator to distribute assets to the person committing the fraud more favorably. Fraud in the execution occurs when a person misrepresents a document in an attempt to get a testator or grantor to sign a will or trust. For example, someone states that what is in front of the grantor or testator for signature is a contract, when in actuality, it's the testator's will or trust. But that's being hidden, so what's being signed is signed without his or her knowledge. Sometimes it's hard to believe that someone in a decedent's life committed fraud in order to receive more from a will or a trust than was intended or wanted by a loved one. But filing a Florida will contest or trust dispute under the theory that the will was procured by fraud is a reasonable action to take. Fraud, like any other trust or probate issue, must be handled quickly in Florida. Don't wait if you're going to dispute a will or a trust. Florida has strict deadlines. If you suspect foul play, act immediately. Again, I'm Reed Bloodworth, the managing partner of Bloodworth Law. If you think someone committed fraud pertaining to a trust or will, give me a call. Let's talk about how Bloodworth Law can help you.